Hi, my name is Alvin Brown. I'm a tax attorney. The topic today is one that comes up very, very often. It's whether somebody is an employee or a contractor. If a person's an employee, there should be W-2 withholding income. If they're contractors, then the person hiring the contractor should file a Form 1099. A lot of employers don't want to pay the withholding, and they don't want to pay the Social Security and these other things. So it's a big issue. You don't have your choice. The IRS audits the employers, and they'll make some substantial changes to the tax returns of employers who erroneously treat people as contractors who are really employees. There's a benefit to employees to make sure their employer is doing the right thing, and that's because you benefit if there is withholding for your Social Security taxes and the other withholdings that basically help you. There are some people who would rather be treated as contractors so that they don't report their income, and that's wrong, and it's fraudulent, and somebody, you can go to jail for not filing all of your income. Everybody, it's easily traceable. You certainly, if you're getting a 1099, you want to file tax returns, and you want to make sure that the 1099s are recorded. The IRS gets copies of the 1099s, and it's a permanent record. If the IRS has some record of the fact that you've received income, then you certainly have to file those returns and include that as your income. There's a lot of close lines between who's an employer, who's a contractor, and who's an employee. I'm going to read you something from the Internal Revenue Code. I normally do this, these little YouTube things that I do normally off the top of my head. This one, there's some statutory definitions. I'm looking at section 3121D of the Internal Revenue Code. There's a statutory definition for an employee. It includes an officer of a corporation or an individual who, under the common law rules applicable in determining employer-employee relationship, has a status of employee. Well, the common law rules are, maybe there's about 20 factors that the IRS looks at if it's confusing, but I think the biggest one, and the one that's critical, is control. If you're doing exactly what the person tells you to do, you're doing it what they want, how they want, and they control you as to the details of what you're doing, then I would say that the chances are 99.9% you're going to be treated as an employee because you control. Other factors that they look at: are you doing the work on the premises of the employer? Are you being trained for this? What about your tools? I had a recent case of some rug stores, and the IRS said, hey, the people who lay the rugs are employees, and we made a determination that the fact that they simply did the work all on their own, and there was no supervision, no management. All they did is get the address and they did the work, and in fact they even used their own tools. So they conceded very quickly. That's an example of what I see here on that issue. There's another statutory definition that a full-time life insurance salesman is an employee. Home workers are employees. Anyhow, I'm not going to get into the rest of the statute that deals with that, but I just wanted to alert you to the fact that it's a complicated issue. When we get that kind of a case, we as we do in any legal issue, we'll write a legal memorandum to the IRS on behalf of the employer. The issue comes up because the IRS is auditing employers. And by the way, I've had some criminal cases where the IRS has taken a position that the employer has done this willfully. That is, he is willfully evading taxes by falsely claiming that a person is a subcontractor and not an employee. So that's a very serious issue. The other thing, I've gotten a lot of calls from people who say, hey, I believe I'm an employee, my employer is treating me as a contractor. I think you should talk to your employer about that. If your employer is not doing the right thing and you think it's wrong, I think you can report it confidentially to the IRS. Honestly, it's fraud when somebody does that. So the IRS will happily receive that, let's call it tip, and they'll examine the employer and they can correct his records. But if it's you versus their employer and he is misclassifying you as a contractor, that's certainly the wrong thing to do. And it's in your interest and in the employer's interest to make sure that the classification of whether you're an employee or contractor is the correct thing. So you'll have to excuse this kind of impromptu discussion. There's an awful lot of case law that deals with the subject, and I follow cases, and you never know which way they're going to turn. They're closely decided. A huge win in a large business. The IRS wanted, they're in Canada, the IRS wanted to treat them as employees when they really were contractors. And what I do in cases like that is I write a legal memo on the facts, on the law. Memo goes to the IRS to explain why we support it with the prevailing case law, and it works. In any event, should you, as an employer or an employee, have this as a problem, don't hesitate to call me. We deal with this issue as we do any other complicated tax issue. My phone number, you can reach me directly, is 703-425-1400, extension 106. My email address is ab@irstaxattorney.com, ab@irstaxattorney.com. This is not the kind of issue that you want to give to an a CPA or an enrolled agent, because it does involve a careful analysis of case law as it may be applied to your situation. Anyway, thanks for listening to this little message. I hope it's been helpful, and of course, if you have any questions, please give me a call.